because of the fourth department. Hear ye, hear ye, hear ye. All persons having business before this court regarding any given attendance that shall be heard.
Be seated. Thank you. The first case on for argument, 1400 People versus Wellington.
Morning. May it please the Honorable Court and learned counsel. This is an appeal out of Herkimer County, and I think at the end of the day, when I worked through the brief here and the record, there were two issues that I had identified. The first issue concerned the waiver of the right to appeal, and the second issue concerned the gentleman's continued representation by his assigned attorney.
You really need to show that the conflict issue and the issue that the lawyer impacted the plea, correct? That's ultimately what you have to do.
Well, that's a good question, because when I looked at the case, because the inquiry regarding the potential conflict, if you will, was rather superficial, it actually resulted in a little burden shifting, with all due respect to the way that the court set up.
But let's assume for the sake of argument that that waiver of the conflict was invalid. Let's just assume that.
Okay.
Let's go to the heart of it, I would think, in terms of how did this impact the plea?
Okay. Had the inquiry been in more detail, it might have shown that there was an actual conflict, which had an actual conflict been established, then actually it would have been more or less a per se showing of prejudice.
So
but,
the record's insufficient for us to review this?
Well, I'm not saying that, but I'm saying because the inquiry was rather superficial, it actually left the impression of only a potential conflict. And when you work through the sequence of events, what happens is, because there's only a showing on this record of possibly a potential conflict, then according to the law, yeah, the burden stays with the defendant. And as learned counsel pointed out, then the recourse would be to a CPL 440. But the problem with that is, by shifting the burden onto the defendant because of inadequate record development over which the defendant had no control, he's basically then put in a position where on a 440 motion, he's not only incarcerated, which is strike one, but he has to proceed pro se, which is strike two. And this is all because the trial court...
It's really a two-pronged conflict, right? Do I have that right?
As near as I can determine. And again, that was kind of reading...
It's the O'Donnell issue, the lawyer
right.
O'Donnell.
Right.
And then whether the other person that's referred to in the record was a co-defendant or witness. And that seems to have been denied pretty well, correct?
I didn't catch that. Seems to
have been denied pretty well. I thought that Bannister basically said, well, it's not a co-defendant, it's not a witness. So isn't that conflict out of the mix here?
Well, again, I'm not really sure because there's never an inquiry. And to some extent, once the prosecutor was alerted to that potential conflict, if there was any potential for a superseding indictment, the prosecutor may have decided as an exercise of discretion not to bring a superseding indictment. Therefore, the second individual never would have been a potential co-defendant, and so on and so forth. So I'm not sure whether that's entirely removed from the record. The thing that jumps out is on this case, the defense counsel seems to have just shown no interest in working this case up pre-trial for whatever reason.
Well, he went to see the client in jail, correct?
He went to see the client in jail.
Didn't the client say, don't come see me anymore or something like that?
I believe so, but then when you look elsewhere in the records, you learn that the client works with mental limitations. There's a learning disability. There's some bad blood between these two gentlemen because of the way the bail application was handled. So how else is the client supposed to express his displeasure other than he starts to do the pro se motion practice on his own? And surprisingly enough, when you work through the record, he files a pro se motion, and I think it's at 161 where finally the prosecution starts producing records that should have been produced, in my opinion, at a very early stage of the trial proceeding so that the defense counsel could have litigated all of these issues pre-trial. But that's, so there's a combination of circumstances in this appeal that I believe require that the conviction be vacated and the matter be sent back to the Herkimer County Court for further proceedings.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Michelle Fassett for the people. I respectfully disagree with opposing counsel. The issue of any potential conflicts was brought up at the very first proceeding where Mr. Bannister was present. The defendant acknowledged that he had discussed this with the trial counsel, and trial counsel said that there was not, in fact, any conflict of interest regarding the other attorney.
The court didn't have any burden at that point to drill down further on this and explore this?
Not if it wasn't a substantial issue that was raised, which it appears it was not. I would state that the court is familiar with the attorneys that are involved. It is a small community.
And it was being deferential to the judgment of the lawyers in terms of disclosing too much. Because if O'Donnell was representing a co-defendant, drilling down on that too much could have hurt the defendant in front of him?
Correct. I would agree with that. And regarding the other defendant, which Attorney Bannister represented, that was the only time, again, that was brought up. Even in the appeal brief, it does not state that this person was a co-defendant, that this person was a potential witness for either the defense or the prosecution. It simply was not a conflict. It was not something that needed to be explored further. The trial counsel said what he had to say, and that was not anything that needed to be expanded on.
Would you say that he got a very favorable deal from this lawyer?
He did. He got a very favorable deal. In the beginning, it appears that the offer was 10 years incarceration. He ended up with 6 years incarceration. That was, although he made the request previously to have substituted counsel, he abandoned that request in accepting this plea. And then at sentencing, he did not renew that request. There just is no basis for an ineffective assistance of counsel.
Thank you, counsel.
Thank you.
Case 1401, People versus Everson.
Good morning, Presiding Justice Whalen. Nate Riley on behalf of Mr. Everson, and may it please the court. Constructive possession is a case built upon circumstantial proof, and the evidence here of actual possession by a third party, Fuentes, negates or effectively rebuts the people's circumstantial proof of constructive possession with respect to criminal possession of a weapon.
Did the defendant have like full access to all of these areas of this apartment, and doesn't that impact upon our determination?
He does have full access to all the areas. If we assume that he was living there, they did contest that. There was some evidence presented that he was a resident there. However, these were common areas. These were areas that were accessible by not only Mr. Everson, but also by his girlfriend that was residing there, and also by the aunt, his sister that was living there.
He need not have exclusive possession. That's part of the argument here. Is that correct?
He was not in exclusive possession of these, Your Honor.
He's a father of twins who lived there?
Correct.
Twin infants?
Correct.
And
Yes.
wasn't the weapon or the weapons found wrapped up in infant clothing inside of a playpen or a crib?
So if I could clarify that for Your Honor a little bit. One of the weapons, so my client is acquitted of the .357, but he's
Correct.
convicted of the .38. And the .38 is wrapped in a child's T-shirt, and it is found inside of a pack and play. However, it is not found inside of a child's room. It is found inside of what's called a storage area, and I believe that's Detective Bailing.
And that's, but in a folded up playpen or crib or
Right.
something.
And so as he's conducting the search of the premises, he's in this very messy area. He bumps into, I think, the playpen, and he says that it falls out, and he discovers that it's in this child's shirt. But again, these were all areas that were under all common areas that were under any of the residents' control there. And I think the Harris case from this court is dispositive, and we rely upon it quite heavily, in which there were a number of cohabitants in that case, and this court vacated the conviction as a result of all the other cohabitants that had access to that area. And we think that that's dispositive when it comes to the sufficiency review of this court. Now, if this court were to say that I lose on sufficiency, we still make, I feel, a fairly strong weight argument. Pursuant to this court's weight review, the court can assess the evidence where acquittal would not have been unreasonable. We feel here that the acquittal would not have been unreasonable because of the acquittal on the first charge. We have essentially identical evidence that's presented with respect to both weapons, and so we know it would have been...
With regard to that weapon, there was some testimony that it required manipulation in order to possibly be operable, isn't that so?
Yes, there is. That, with respect to the 357...
Have determined that because it required manipulation, that was the reason why they didn't feel as though there was proof beyond reasonable doubt of operation?
I don't believe so, because I think that the firearms expert gets up there and says that there is there's a difference between operability and a malfunctioning weapon. He does say it's malfunctioning, but he says that under the penal law it's still operable, which is all that the people were required to prove with respect to the 357 or the 38.
That certainly would get the people past a TOD order, but a jury still could have listened to that evidence and decided, you know what, that's not enough for us.
Perhaps. With respect to the 357, but again, I don't think it's reasonably...
It'd certainly be an argument you'd make maybe in summation on the case at trial, right?
Yeah, I would think that that's something that he would want to focus on quite heavily. And there's additional factors here that would show that, you know, with respect to weight review, that these two weapons were found in the same place. They were both wrapped in cloth, and both lacked any forensic evidence tying my client to possession of either weapon. Actually, the forensic evidence that's presented by Ms. I believe it's Mull, demonstrates that there were fingerprints that matched another party, third party, either Ford or Fuentes, which we feel is dispositive here with respect to the weapons charge. And we would make the same arguments with respect to the drugs charges, because those were found in common areas that were under common control. And again, we rely quite heavily on the Harris case from this court.
Thank you, Counsel.
Thank you so much.
Morning, Your Honors. Brad Oster on behalf of the people. May it please the court. I think the fair takeaway from this is that the jury listened to the evidence that was presented and came up with the proper conclusion that the gun that was wrapped in the infant's t-shirt in a pack and play, both of which those items correspond to the defendant's infant children, they found that that was appropriate circumstantial evidence in terms of establishing dominion and control. I don't think there's also any real question about this back hallway area where the items were found. Certainly it's an area that all people in that apartment have access to, but it's also adjoining the kitchen. There's no door separating it. There was testimony that was used as, or appeared to be used as sort of a common storage area. Obviously the people have to recognize that in establishing dominion and control by circumstantial evidence, we have to rule out all hypotheses except that of guilt. And I think that's exactly what the evidence shows. Again, the jury was able to arguably distinguish between a gun that was found in a pillowcase and one which was found in items that reasonably would not have been in that apartment but for the defendant residing there with his young kids. And I think their conclusion was based upon that.
What about the operability of the weapon?
Certainly that's something that the jury may have considered, and I would agree that I think there was testimony that it was the 357, I believe it was malfunctioning, but was
right.
Still operable.
I think the testimony was operable but not functional.
Right. And certainly their decision could have been made partly based on that. I think there's some validity to the idea that they may have distinguished between the two based on how they were found or how they were hidden, I suppose. But regardless, I don't think there can be any real reasonable question about the dominion and control the defendant had in this apartment. A lot of the cases that both counsel and I look to in determining dominion and control are very distinguishable. There's common areas, there's not real evidence of residence or length of stay, and this case has all of those factors in our favor.
Thank you, Counsel.
Thank you.
Case 14-02, People versus Harvey.
Morning, Your Honors. Kathy Reardon, Monroe County Conflict Defender's Office for Rashad Harvey. A review under both the legal sufficiency and the weight of the evidence standards reveals that the proof of trial failed to establish the criminal possession of the weapon charge. The people's theory was actual possession, and we submit that the facts simply don't support that. The officers responded to a call for a trespass, not a criminal action. There was no observation, there was no testimony, there was observation of a gun, that there was an observation of a bulge in Mr. Harvey's clothes. They had the light shining on him, they saw nothing. Mr. Harvey fell when he walked off of the porch.
There's no sound of a weapon hitting the ground,
Nothing at
anything
all.
like that. But there is the tugging at the waist testimony, which we see in a lot of cases. And certainly the police officer testifies that based upon experience and training, that would indicate that there'd be a weapon present.
And I would submit to the court that we've relied on this court's case in Katy, indicating that simply because somebody's reaching for something, unless there's something further to show that there might be a weapon, that it's
So
really
had the
innocuous
defendant
behavior.
been seized then, which of course he was not, seized immediately after the grabbing, that maybe that's on all fours. But that's not what happened here, right? The defendant was not seized, proceeded into a house, a neighborhood house, or the neighbor's house.
That's correct.
Right, and that's where the weapon was found, and near some kind of
Underneath a planter.
a planter. Yeah.
Yeah.
And so they had permission to go into the house. They asked for permission.
They did.
They went in, and the circumstantial evidence then continues. Right, you've got the homeowners saying that they were there and they did not notice any weapon coming in. And there shouldn't have been a weapon there, and there's the weapon. I mean, the circumstantial evidence is building, right?
However, and here's the contrary argument to that. When the grandmother went out to tell the people, get off the porch, you're making too much noise, her testimony was she doesn't recall how many people were there, she doesn't recall who were there. She said it could have been 4 or 5, I don't know how many. And then she goes to the back room and with the granddaughter and falls asleep. The grandfather goes upstairs and watches TV and falls asleep. So there's a 3 to 3.5 hour period of time when they're paying absolutely no attention to a locked door where anybody could have walked into that house.
An unlocked door, you're saying, not a locked
Excuse me, an
door.
unlocked door,
Yeah.
where anybody could have walked into that house. There was entrance to the front and to the back
So
of the
that goes
house,
to the weight of the circumstantial evidence, doesn't it?
which is essentially our
Right.
argument. But I mean, anybody could have walked in that house and placed that gun there, and there simply was not enough. There was no forensic evidence, there was no admission, there was nothing to tie Mr. Harvey to that weapon. If the court finds that the CPW falls, then the tampering charge also has to fall because they're connected. We would simply submit to the court that the weight of the evidence and legal sufficiency, because this is actual possession and not a constructive possession, simply wasn't even close to determine that this could have stood. Thank you.
Thank you, counsel.
May it please the court, Lisa Gray from the People. Good morning, Your Honors. With respect to the weight of the evidence argument, there's one critical fact, and that is out of the group of people standing there, the police officer saw one person, the defendant, run into that house upon his arrival. So I mean, of course, defendant puts forth this theory that somebody could have run into this house, ditched this gun, we just don't know who. Well, we do, because the police officer saw the defendant run into the house and run out 15 to 20 seconds later. So I think that's...
Well, not only did the defendant run into the house, but there's also the testimony of the observation of the defendant grabbing at his waist.
On a hot, humid August
falling,
night.
and then going into the house.
Correct, while he's wearing a heavy hoodie. So with respect to that, Your Honor, the weight of the evidence certainly was present during the trial. And if there are any other questions, I would rest of my papers.
Thank you, counsel.
Thank you.
Cases 1403, 1404, People versus Boyd.
Good morning, Your Honors. May it please the Court, Phil Rothschild, legal aid for Mr. Boyd. There was a legal sentence in this case that vitiated the plea. Sex abuse in the first degree is a Class D felony with a minimum of 2 years in prison and 3 years of post-release supervision.
Although you could do 1 year.
You could, however, the post-release supervision is mandatory.
No question about that,
Yes.
but that could be solved if it went back. I guess my question is, we're not even sure what the sentence was.
Well, the sentence imposed on this new plea was time served with no
That's what I
mention
mean.
whatsoever.
That's my point.
Yes,
I don't really know
and-
what it referred to.
Well, I understand that there are cases that talk about time served not being an actual sentence, but I believe those are mostly dealing with probationary sentences. And here we have basically the underlying sentence itself. And as I said, the post-release supervision is mandatory. It's mandatory 3 years. And that the failure to talk about or do anything about it, I believe, makes this sentence illegal. And this court has repeatedly said, and sua sponte ruled, they will not allow a legal sentence to stand. Now, the remedy in this case is to vacate the sentence, afford Mr. Boyd the benefit of his bargain, the opportunity to withdraw the plea. We would ask this court reverse and remand for resentencing, giving Mr. Boyd that opportunity. If this court does not find that to be the case, or if it does, I guess, we would still point to is the trial court erred in relying upon stale information in determining the SOAR classification and in failing to hold a hearing. The court at sentencing, first of all, there was no mention whatsoever in the plea bargain. The court at sentencing said a hearing was unnecessary, but the court is obliged to make an independent determination under Correctional Law 168 to comport with due process. Here, more than 4 years have passed since the original finding. When the classification was imposed at sentencing, defense counsel said nothing. Mr. Boyd objected to it. At a subsequent proceeding, I believe it was on the failure to register charge, new counsel did object, both orally and in writing, to the classification process, the summary process, asserting that witnesses were never called, there's never questioned any of the stale information relied upon, and or any reference to the programs that Mr. Boyd may have engaged in while in prison. While there is no objection made at sentencing, we would submit the matter is still preserved either in the interest of justice or by subsequent counsel's objections to this, or because original counsel was effectively ineffective in failing to defend his clients or preserve his clients' rights in this matter. And we would ask, alternatively, that this court reverse and remand for a de novo SOAR determination if it does not find in the first point.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Ken Tyler for the people. It's a somewhat unusual case, a time-served sentence in the context of a felony, and I agree it's not entirely clear what the time served was meant to refer to, and from a purely numerical standpoint, I think the undercurrent of it is the defendant had served significant time while the matter was in pretrial proceedings. It had been remitted from this court on a previous occasion. By that time, the defendant had served some time in jail, and I think the court was effectuating what it saw was a fair disposition at that point.
But maybe the fair disposition wasn't legal.
I mean, that's possible. I would submit to you, Judge, that the validity of a sentence becomes moot if the sentence has been fully served, though. So I'm not really sure you get to that point. Beyond that, there was some reference in the plea, or excuse me, in the appellant's brief to the voluntariness of the plea. I believe it may be just in the table of contents. I would submit to you any claim related to the voluntariness of the plea, to the extent that's a due process violation claim, which he seeks to have this plea vacated or withdrawn. That wasn't preserved because he had the opportunity to raise that issue below. He chose not to for understandable reasons. It was a favorable disposition, and under the Williams case that we cite from the Court of Appeals, that's the type of issue that needs preservation. With respect to the SOAR classification claim, the manner in which that determination was reached, I would submit to you that's not properly before the court on an appeal from the judgment of conviction.
And if we send it back to the court below, that's going to be moot anyway, right?
Sure, sure. Thank you.
Thank you, counsel. Case 1405, People v. Collin.
Good morning. May it please the court. Diane Russell, representing Eli Colon. This is a conviction for criminal sexual act in the first degree after a jury trial where the main witness in the case was the child witness victim, who was 7 years old at the time of the incident and about 8 years old when he testified. The credibility of this witness was, in fact, the key factor here. And while I've raised a number of issues in my brief, I do wish to address the main point, which is this refusal by the court to turn over significant mental health records relating to this particular witness, which may have borne on the credibility of that witness and that witness's ability to
There
recall.
was an in-camera review of those records, isn't that correct? It appears that from the record, there was many references to Judge Valentino conducting an in-camera.
This is a case where the matter was in front of Justice Valentino,
Yes.
and then it was transferred for trial to County Court Judge Connell.
Connell.
However, Judge Valentino did an in-camera review of the first set of records that were subpoenaed, which was Rochester Mental Health and the City School District records. And he made a finding on the record about what was relevant, turning over 8 pages of those Rochester Mental Health records and refusing to turn over any of the school records. Those Rochester Mental Health records, once counsel received them, revealed that in fact this child witness had had what appeared to be 2 psychiatric admissions, one at Strong Hospital and one at Rochester General. So she then did a second set of subpoenas, which Justice Valentino signed, but by the time that those were returnable, the case was now in front of Judge Connell. And I would argue, Your Honors, that the record does not establish that there was ever an in-camera review of that second set of very important records.
Help me with the record. Was it requested? Was that in-camera review requested?
Several times by defense counsel, and Judge Connell certainly never did the in-camera review himself. He made several comments to counsel over a period of time that Justice Valentino had told him he had reviewed all the records that he had, but there was never anything concrete in the record that said that these actual important records, the Strong Hospital records, the Rochester General Hospital records, had actually been reviewed by Justice Valentino. And Judge Connell's clear that he did not have them, even though the entire file had supposedly been turned over to Justice Connell.
Of course, that's the other problem here. Now those records are gone, aren't they?
As I put in my brief, I did try to unravel what had happened and was told by the clerk's office, because of the age of this case, that they couldn't tell me one way or another, and that it appeared that the file had been purged.
Not only is it that the records may be gone, but the witness is no longer available if there was to be a reconstruction hearing. Judge Connell's no longer with us.
Yes, this is absolutely true. That's right. So it's a very difficult situation, but may I say, it's compounded. The cases are, there are many cases on this, but generally when a court has withheld records, the court then looks to, the appellate courts look to, well, what happened at the trial anyway? Did defense counsel have a full opportunity to cross-examine on the same issues that, maybe were not turned over in a mental health record? What happened here? That didn't happen. Instead of a full cross-examination of the child witness, and the other person who had known about the mental health issues was the mother, the court, Judge Connell, restricted the cross-examination as to particular diagnoses, particular admissions into the hospital, and the child himself could not adequately testify to his own mental health diagnoses. There was a serious diagnosis mentioned in that initial record, which was bipolar disorder. That has manifestations of psychosis. Then compounding the issue is defense counsel's attempt or offer of proof on an expert witness, a psychologist, who would then testify.
There was an offer of proof there.
Yes.
Is that correct?
Yes.
And didn't the court conclude that she was testifying from records or about records that were not admitted into evidence?
No, because she wasn't allowed to see those records. She was only able to testify from the 8 pages of records that had been turned over. And ultimately, the court concluded that since there was no evidence in the record to support her testimony, and she,
I think that's
a
way of saying it. She was testifying from something that was not in evidence.
Well, right, the records themselves weren't in evidence, but
only 8 pages.
Right, I think she only had access to 8 pages, and so that's what she would have based her testimony on.
She never examined the child.
She did not. She did not. But I think, I believe this court in Thurston looked at a similar situation and said, you can't, the court can't withhold records and then preclude and blame the defense because the expert witness was not allowed to see the records. So in this case, Your Honors, I think there was just a cumulative effect of this withholding of very important information, which prevented my client from presenting his defense in the case.
Part of the puzzle now is the records are gone.
Well,
and that brings me to another question. Why did it take so long to get this appeal perfected?
My understanding is, and obviously I picked this up just a little while ago, my understanding is that the appellant here believed that his family had hired appellate counsel.
This is back in 2007.
I know. So that's my understanding of what happened.
I think we have your argument, counsel.
Okay, thank you.
Morning, Your Honor. Scott Miles for the people. May it please the court. As a preliminary matter, in regards to the mental health records, it's clear from the record and from the request made by defendant's counsel at trial that she was seeking these records for the use of impeaching the general credibility of the victim, which case law from this very court is very clear is an impermissible use of such records. So I think that is something we need to look at first before looking at the unfortunate fact that we can no longer access these records because for whatever happened to them, they're not available. In regards to the record below of whether or not there was ever an in-camera review, I think the record is clear. I respectfully disagree with opposing counsel. Judge Connell stated several times, at the very beginning of the trial, he said, I've confirmed with Judge Valentino that he's reviewed all available records and he's made the determination that what's been turned over so far is all that you are entitled to. Later on...
So you disagree with the second subpoena, the second set of records coming to the court after Justice Valentino had done his in-camera review? That didn't occur, is your argument?
It's unclear whether or not the second set of records ever were made available. I agree, that is unclear, whether those records ever appeared or not. But Judge Connell, again, later on in the trial said, I confirmed with Judge Valentino again that he's reviewed all the records that have come in and he's made his determination. So the idea that there was some records available that there was never an in-camera review done, I don't believe that's the case. But again, I don't even think we need to get that far because the use that those records were being sought for is an impermissible use. Unless there are any other questions, thank you.
Thank you, counsel. 1406, People versus Hickson. It appears you're alone.
It appears so. Good morning, Your Honors. I'll just make it very simple here. The appeal waiver in this case, it's evident from the record it was knowing, voluntary, and intelligent. Therefore, it precludes defendant's challenge to both his plea and his sentence. If anybody has any questions, I'm happy to answer. Otherwise, I'll rely on my brief.
Thank you, counsel.
Thank you.
Case 1407, 1408, Marino versus Elliott.
Good morning, Your Honors. May it please the court. My client alleged numerous examples of a change in circumstances to warrant a hearing on the best interests of the children. As the panel is aware, he only needs to establish one of those. The standard of review here is abuse of discretion, a high standard for the mother to overcome. Family court did not abuse its discretion in transferring primary placement to the father. There was no question that the father went above and beyond for these children. For example, he traveled 2,000 miles 1 weekend per month to spend 2 days with them. He fostered a relationship between the children, the mother, and her family. On the other hand, the mother evaded her jail sentence for weeks. She engaged in parental alienation on numerous occasions. Other examples of the mother's misconduct are mentioned in my brief. Lastly, family court did not err in granting the father's motion to dismiss. The mother's allegations in her January 18th and February 3rd modification petitions did not establish a sufficient change in circumstances to warrant a hearing because the allegations that she made were previously litigated and/or were conclusory. These petitions were filed less than 45 days after the last order was entered. I also note that based on the record on appeal, the mother had filed 4 violation petitions and family court had scheduled a fact-finding hearing on those petitions. Unless there are questions, I rest on my brief.
No questions. Thank you,
Counsel.
Morning, Vivian Strachey, for the attorney for the children. I would just point out that the court had extensive history with these parties. We had had a trial every year for 10 years. So the judge deciding finally to change placement was not something done lightly. She issued an extensive written decision, thought about it very carefully, had warned the mother previously when she sentenced her to incarceration for violating the prior orders. Listen, if this happens again, I'm changing placement. So the mother was definitely, there was nothing left to do in terms of addressing the mother's continual violations.
And the court's ruling is entitled to great deference from this court, is that correct?
That's correct. I would also note the order of protection issue that is complained about on appeal, that the court had issued an order of protection that the mother stay away from the father until the children's 18th birthday. That was specifically upheld by this court less than a year ago. And then finally, the new petitions that the mother had filed, shortly after the decision. Again, she was relying on old documents, old facts, and I think the court was well within its discretion to dismiss those petitions.
Thank you, Counsel.
Thank you.
Case 1409, Richard K.H. versus Emily P.
Good morning, Peter DiGiorgio.
Let's just wait until counsel gets situated, please.
I'm sorry.
No, that's quite all right. Thank you. Please proceed, counsel.
Peter DiGiorgio for the appellant. Very limited issue in my brief, or 2 issues. This is a motion to dismiss a paternity petition based upon the doctrine of equitable estoppel. I argue in the brief that based upon the moving papers that were before the court should have conducted a hearing. The standard is best interests. The moving papers of the affidavit in opposition basically alleged that the lawful father had a regular, consistent parenting time, and the child calls him daddy. There's no elaboration on how frequent visitation was. And of course, as this court knows, that had the court conducted or had a hearing, it could have had a Lincoln hearing. This child was, I believe, 3, even though was kind of young. The court relied on the neglect proceeding and the permanency hearings that it conducted over a period of time involving the mother and the father. And none of those were attached to the moving papers in the form of sworn allegations. And the record for this court to review would be unclear as to whether the court's findings was consistent with what occurred during that trial. So I'd argue that in order to make, and I think the standard is to make a determination without a hearing, is that did it have sufficient facts to make an informed decision?
Can the court rely on those prior proceedings? The court presided over them.
It did, but there's no way for this court to review them because...
Could you make them part of the record?
They weren't even identified. The dates of them were not identified. And one further argument, Richard, the petitioner, Richard K., wasn't a party to those proceedings. Now,
he also didn't file an appeal here, did he?
Yeah, I see that. I know...
It's his petition that was dismissed.
Correct. I'm not sure why that happened. I wasn't involved in the trial, and I know that was raised in the respondent's brief. And I would argue that that's not fatal to the mother raising this issue, especially when it involves the best interest of her child. I think she has an independent right to raise an issue that it's in her child's best interest to have the proper father adjudicated. And again, this petition was just requesting genetic markering. I'll let the AFC advocate for the child's point of view, but the child was young, and I don't know how the court, based upon the limited papers it had before it, could make that determination in best interest.
I think we have that argument.
Thank you.
Your Honors, I'm I'm Scott Otis for the respondent, Mr. Marsh. Another appeal that was never filed was regarding Judge King's custody determination following the neglect trial, 3 years of neglect trial. And through the entire neglect trial, his focus was this best interest of this child, and through that trial, he made a custody determination that Mr. Marsh had, not only was he named, not only was the child named after him, not only was there an acknowledgement of paternity signed by the mother, not only did she not respond for 3 years of a neglect trial and say, no, he might not be the dad, but during that entire time, the father himself...
And Mr. Harris didn't object and didn't raise anything.
Mr. Harris, in fairness, was not part of those proceedings, and nor was anybody...
But he was a neighbor. He knew the relationships.
He was a neighbor to where the child lived in foster care, and yet there was no suggestion that he maintained or developed any kind of a relationship with the child, which Judge King pointed out in his decision. So the notion that he didn't have evidence before him just isn't true, and he did, in fact, in his decision, cite the neglect proceedings. He said, I've done 3 hearings now, permanence hearings, all focused on this child's best interests, and through that, I've made a decision to place this child with this father he's named after. At that point, Mr. Marsh's paternity is good as against anybody. He doesn't need anybody else that might come in and make a decision if that might be a better dad, so we should give him a genetic marker test. At that point, he's established a relationship with the child. He's already fulfilled all the tests.
Wasn't he paying child support?
He paid child support the entire 3 years.
Thank you, Counsel.
Thanks.
Please, the court. Good morning, Crystal Rupert, attorney for the child. I note, as counsel did prior to me, that Mr. Harris did not perfect this appeal. I probably know the answer why, but it's clearly not part of the record. I don't believe he's able to be here with us today. However, I don't think that that changes the fact that my client, the child, did nothing wrong in this. Whether his mom lied in signing an acknowledgement of paternity, whether his father should or shouldn't have known that he was his father, is through no fault of my client. He's 4 years old. He spent his first 3 years of his life in the foster care system, living with a foster family with whom he was extremely bonded. And the court does acknowledge that there were permanency hearings that it presided over and that I was a part of. I don't believe that they necessarily supported the decision that the court ultimately reached, and I think that they should be part of this record on appeal so that the court could consider what was actually stated in some of those permanency planning hearings and how it would
During
impact
the
my client.
foster placement, there was regular contact and visitation by getting my name by Mr. Marsh. Is that correct?
It's not accurate that it was throughout those proceedings. It's accurate that there came a time when he decided to do services and engage in them. They were quite late in the game. In fact, this was a case that, in my opinion, could have been ripe for a termination of parental rights proceeding. We didn't get to that point. Very, very, very late in the game, Mr. Marsh began to engage in services, and I think that the court moved quite quickly towards its decision to give him a trial discharge and thereafter a final discharge. And I believe that if the permanency planning hearings had been attached as part of the record, you would have noted that they were, all of those decisions were over my objection at the time.
I understand, Counsel.
Thank you.
Thank you. Case 1410, in the matter of Callie H. You appear to be alone.
Didn't realize I was going to be alone. I'll be very brief then. I'd just like you to really focus on my point, the failure to plan. I think that my client proposed at least one, if not two, viable resources for this child. And as she was incarcerated, that was what her obligation was to do, because she was not able to do any more of her menu while she was in. So. I think the court clearly didn't even consider her, or apparently didn't even think they could consider her because she wasn't certified. But being certified isn't required when you're just asking for custody of your granddaughter. So I believe that she could have been considered. She's a viable resource, CNA, able to take care of all the child's medical needs.
We'll take a look at it. Thank you, Counsel. Case 1411, Christopher Geraci versus Derico of East Amherst Court.
Good morning, Your Honors. May it please the court. I'd like to begin by just addressing the arguments learned counsel for the respondents raised in the existing case law, mainly Palmer v. Barnes and Nobles. Our case is factually dissimilar to this case in the respects that Derico East Amherst was a McDonald's franchise. In the franchise agreement and through the testimony of the owner and the construction manager, they established that they are attractive to children, want children and families.
Let me ask you this, counsel. Isn't the threshold question here is whether or not it's a dangerous condition?
Correct, Your Honor.
Is that door entering the courtroom, is that a dangerous condition?
As it sits here today, it is not, Your Honor.
This one?
No, it is not, Your Honor.
Okay.
And the difference is that I would assume all of us are adults here entering into this area. We're not a mother juggling two children into this area where accidents can happen because of
Children
this.
frequent Barnes and Noble, I take it from time to time anyway.
I've heard so, Your Honor.
Okay.
And in this case, McDonald's said that they wanted this environment for children to come in, but McDonald's also recognized the risk of this injury happening. The franchise owner testified that certain doors in his McDonald's franchises did have these finger guards in place. The plaintiff's expert opined that these finger guards were in place on doors with closing mechanisms, but this is illogical because with the closing mechanisms, it closes at a standard rate of speed where you can remove your finger. On these free swinging doors where the pinch guards would truly be needed, anybody could apply any amount of force and close the door quickly, which happened in this case. As far as our next point.
There's no question that McDonald's could have put them on there. Does that require that they must?
It's not required that they must, but it shows that they were aware of the ability for this thing to happen. They had constructive notice that these injuries could occur in the stall doors or in any doors for that matter.
So anybody that has a door in their home or their place of business would recognize that people can get their fingers pinched in them.
Yes, Your Honor.
Does that mean everybody has to have these door guards?
Again, Your Honor, it doesn't. If you're cultivating this atmosphere where you want families and children to come in, this specific McDonald's didn't have a play place, but some McDonald's do, and you want your children to come in, you want the children to be safe. So it's the plaintiff's contention that if you recognize that there should be door guards on some doors, you should put them on all doors. If you have no further questions, I'll rest on the rest of my papers.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Megan Brown on behalf of the respondents, Derico and McDonald's. Justice DeJoseph, I think you hit it on the head. This door at McDonald's was not any more of a dangerous condition than the doors to this courtroom, and the facts are directly on all fours with this.
But don't the facts change depending upon where the door is located? In other words, if this were a daycare center and it was populated by children all day long, does the premise liability or the premise owner have an obligation to know that, to recognize that these kids are running around and that there may be pinch points in doors that it may not reasonably be required to protect against if it were just adults?
I think that goes more to an issue of supervision, and I've cited numerous cases that did involve schools. I would direct you to the Walsh case, where school children, the claims of the premises liability negligence claims were dismissed on summary judgment under very analogous circumstances, children who had fingers pinched in doors, whereas the claims may have survived in those cases was negligent supervision, which is certainly not an issue here. And at McDonald's, we don't have a school with teachers or a daycare with people caring for the children. And so that, I think, is the distinction between that type of an environment. It's not that the door needs to be different, it's that it's an environment where the supervision of the children is different, and that's not at play in this case.
Thank you, counsel.
Thank you.
Case 1412, Holland versus McCluskey. Proceed, counsel.
May it please the court, my name is Chaim Jaffe. I'm with the Scalero Law Firm in Syracuse, New York, and we represent the appellant in this matter. This is my colleague and partner, Douglas Smar. The appellant is here this morning, Your Honors, asking you to reverse the Supreme Court's October 5th, 2017 order, which denied her summary.
Jaffe?
Yes, sir.
Good morning, sir.
Good morning, Your Honor.
Both sides move for summary judgment.
Yes.
Both sides contend, therefore, this can be decided as a matter of law. Correct?
Correct.
And what you want us to do, what both sides want us to do, is to read these deeds very closely and determine what they mean as a matter of law, correct?
We're asking you to, Your Honor, we're asking this court to read the deeds in accordance with the opinions offered by the experts and reach a conclusion.
As a matter of law.
As a matter of law.
So now you get not just one judge, now you get 5 to look at this.
Yes, and Judge Fandrich did not issue a written decision, and there was no explanation as to why he reached the decision that he did. What this case comes down to, Your Honors, is a October 31st, 1878 deed from Richard and Eliza Morgan to the Cayuga Southern Railroad, which through man's conveyances became the Lehigh Valley Railroad. The conveyance that we're here discussing states in part that the Morgans conveyed to the Cayuga Southern Railroad their successors.
You know the record very well, Mr. Jeffrey, just so I can assure you. I know there's been a lot of effort put into this case.
Yes,
but
Your
it
Honor.
seems to me it's a pretty discrete issue as a matter of law to look at this, drill down on it, look at these deeds very closely, consider the expert affidavits, and then make the best call we can as a court, correct?
Correct, Your Honor.
Thank you.
This case in Corning, in my opinion, is on all squares with our fact case. This court in Corning held that the term right-of-way has a special significance with respect to railroads, which are very different from the term that is generally used to describe real property. I'm jumping ahead in this court's decision. It says the use of the term right-of-way to describe a right-of-way owned by a railroad in fee is quite common. Now, I know respondent made a whole argument as to we have to look at the initial grant to determine whether or not it's a fee or whether or not it is going to be an easement or a right-of-way. It's our position that in this specific case, the definition is that it is a fee simple interest. Our expert opined that this court's use of the term right-of-way is merely a descriptive element of the conveyance and not a statement or a limitation of the interest that was conveyed. Now, in their brief, respondent makes a 4-point argument that the plain language of the Morgan deed to the railroad company only conveyed an easement in this matter, and we disagree. First, respondent claims that the Morgan deed does not use the word land, which according to them is indicative that the conveyance was only intended to be an easement and not a fee simple absolute transfer. However, this court in Corning specifically said, and I quote, I'm sorry, it's not a quote, the railroad right-of-way means the land occupied, and it used the word land. That is what this court said back in 1961. Second, respondent incorrectly argues that since the Morgan deed does not include precise measurements to describe the conveyance, that only an easement was intended. Mr. Hoffman opined in his affidavit at great length that natural monuments and objects will control over other descriptions that might be in the deed. In this case, there is a deed call to the lake. As I read earlier, the conveyance said to the lake, which in our opinion, according to the case law and according to Mr. Hoffman, trumps whatever descriptive language in terms of measurements may have been contained in the deed. Third, respondent relies on Yates versus Van de Bogart for the proposition that railroad companies are presumed to acquire land for railroad purposes. Their contention is because the Lehigh Valley Railroad went out of business and they folded, that the land was no longer necessary for the purpose to which they believed it was granted, which in this case was.
Could I ask you a question? The westerly boundary, I think, is the lake is there.
Correct.
Where does the easterly boundary start?
I have to refer back to the deed, Justice Joseph, to tell you exactly where it is. But from 1984 until 2011, there was never an inkling that the Wells College claimed any ownership interest into this land. Going back to respondent's brief, they claim get under Yates that since the railroad was out of business, it no longer needed the conveyance that was made to them. Therefore, that's indicative of the fact that it was an easement and not intended to be a fee. However, the court in Yates went on to say when the land was no longer necessary for the purpose of the railroad, it had the right to sell and convey the same. The court came to the conclusion that simply because the land may have been acquired for a specific purpose does not diminish the ownership interest in the land that was acquired. Same applies here. It's uncontested the Lehigh Valley Railroad went out of business. It does not diminish the fact that they received a fee interest conveyance from the Morgans back in 1878.
You should wrap up, counsel. We've got that argument.
Okay. They also rely on the fact that if you go back to the DEC deeds, the language in those deeds are different than the language in the deeds that are issued before this court. Mr. Hoffman goes to great length to explain that the deeds and the language in the Fort and Mandel deeds are not relevant to this court's determination as to what the specific intent was in the deeds before this court. It's generally accepted among the real property experts that you don't look at languages from other deeds to come to a conclusion about deeds in a different matter unless there's a specific reference. And that wasn't the case here.
Okay, counsel, time.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors. John Callahan on behalf of the respondent, Wells College. This morning with me is my colleague Liza Magley and Laura McCluskey, one of the individual defendants in this case. I just want to respond.
Mr. Callahan, do I have that right, that this is a question of law and both sides agree to that?
Absolutely, Judge. And
you're going to tell us that the Corning case, the issue about right-of-way had to do with notice, correct?
Exactly.
If I could interrupt just for a second. Sorry. Counsel, you've indicated that one of the people with you is one of the defendants in the case and not an attorney?
Correct.
Yeah, I'm going to ask that you get behind the bar and go back into.
I'm sorry, Judge.
That's quite all right. Thank you. Excuse me.
Justice Kern, you hit the nail right on the head. And when you said in response to our question to Mr. Jaffe, isn't this really, you want 5 people to weigh in on the 1878 conveyance from Rich and Eliza Morgan to the Cuba Southern Railroad. And that's exactly what the appellant is asking you to do. And yes, there are 2 expert affidavits in the record. However, I submit to this court that you're being asked to simply interpret language in a conveying instrument, just like you'd be asked in another case to interpret what a contract means. You know, when I got into this case, as I've outlined in my affidavit and started to do some preliminary research, it raised some real questions as to whether or not the Hollands own this property and whether or not Lehigh Valley's predecessor in interest actually got a fee. I then got some guidance from Mr. Nessel, and knowing that Justice Fandrick had a real estate practice, before he went onto the bench, I thought that it would be beneficial to counter what Mr. Jaffe had to say. But this is not a battle of the experts. The 5 of you have all practiced law before you got to this position, and you know how to interpret deeds and contracts, and that's what we're asking you to do. Just a couple of points here, because it sounds like you've covered the record quite well, and I acknowledge Mr. Jaffe's well-prepared presentation of the briefs and the records, because this is a hotly contested case, as you might imagine. But this property in issue is directly in front of the college's Morgan House. It does not interfere, or excuse me, the Holland House, which is to the immediate north of Morgan House, has its own lake frontage of approximately 125 feet. If you affirm the lower court's ruling, you're not denying the Hollands access to the lake or the use of the portion of the former railroad bed that crosses through their property. What's at issue is just that portion of the former railroad bed that runs through the Holland House, excuse me, the Morgan House parcel and the lakefront. And I submit to this court that Corning is not on all fours with our situation.
The reason I just gave you, is that what you're going to tell me, is that it has to do with notice in Corning?
It
that
does.
Is the right-of-way should have put somebody else on notice. I forget the party's names, forgive me.
Right,
But
it should have put Mr. Corning on notice. But what's important in the Corning case, Justice Curran and everyone else, is that there was no dispute that you didn't look at this subsequent deed in the chain of title to decide what type of interest Mr. Corning got. You looked at the original document, which was not a deed. It was an agreement between Mr. Farmer Valentine and a gentleman named, the railroad. And it was a promise to convey this land in the event the railroad built the railroad and that they built a station nearby for, a depot. And what happened in Corning is that they never did a deed. So this agreement was out there, but not necessarily in the chain of title, and that's why Mr. Corning thought, hey, right away, easement, I, own the fee, I'm getting the fee. They never got, the fee back then. But what's also instructive about Corning, and it's right in the decision, after they go through why a right-of-way can mean an easement or a fee, which I wholeheartedly agree with. But a critical distinction in these chains of title, in the Morgan chain of title, every subsequent deed after Richard and Eliza Morgan died talked about, the conveyance talked about transferring the land subject to the rights of the Cuga Southern Railroad or its successor, the Lehigh Valley, not accepting from the parcel this instrument that the Morgan signed in 1878. And the Corning Court, back in 1961, I believe, when the decision came down.
I think that the deed from Avery to Holland does accept.
That's correct, Judge.
Yeah.
So we've got this difference, we've got these two different chains. We've got the Morgan chain using subject to, and we've got the Holland chain using accepting from. And of course, we've pointed out with authority, and I believe even Mr. Hoffman, appellant's expert, agrees that the relevant chain, they don't want us to look at the Mandel and Fort deeds, they want us to focus on our chain of title. And our chain of title says every subsequent transfer was subject to the rights. And subject to the rights meaning somebody has some rights. Accepting from means somebody has all the rights. And the Corning Court noted this important distinction because the conveyance in question that Mr. Corning was relying on used the accepting from language. And the appellate division said, hey, wait a minute, you're on notice that not only was there a transfer, but they accepted out this parcel. How can you claim you were in the dark about what the railroad company got from Mr. Valentine? So unless the court has any other questions, we rest on our papers, and thank you for your attention.
Thank you, counsel. Case 1413, the Bank of New York Mellon versus Simmons.
May it please the court, James Simmons for myself. Both sides have moved for summary judgment in this matter, and the ultimate issue in this case is whether a certain payment, the April 1st, 2009 payment, was made. The plaintiff bases its motion for summary judgment based on an affidavit by a contract management coordinator who states that he reviewed and relied on certain business records related to the loan, and that according to the records, the last payment was applied to the installment due for March 1st, 2009. Those records were not identified, and they were not supplied, they were not attached. We don't have any idea what those records, what's in those records, or anything at this time. I submit that those records are hearsay, and the statement of the contract coordinator is conclusory. And a main reason why I say this is that during the early part of 2009, the defendant, in discussions with the plaintiff, was provided with certain records that they had called detailed transaction histories, a total of eight pages of transactions. And in defendant's motion, those detailed transaction histories were attached to the motion for summary judgment. And there's one particular transaction of importance, and that's the very last transaction on those pages, and that's transaction 92. And transaction 92 says that for the due date of April 1st, 2009, a certain payment was made, that payment being $1,541.24. Okay. The plaintiff says that was only a partial payment. That was not a partial payment. The plaintiff has provided no reasons why that would be a partial payment, and no support for this allegation. And in fact, in a plaintiff's letter that dated March 14, which is in the record, the letter states, effective with your December 1st, 2008 installment, your monthly mortgage payment was adjusted to $1,541.24. It was not a partial payment. That particular record shows that for that due date and issue here, April 1st, 2009, the payment was made. The plaintiff has not provided the documents, transactions, or whatever upon which they base.
And with the absence of those documents, your argument is that summary judgment shouldn't have been granted.
That's correct, Your Honor. But basically, you know, and other issues in the case, you know, the defendant is of the position that not only that payment, but there would be additional payments that if funds were properly applied to the loan, it would not only have covered the April 1st, 2009 payment, but future payments, one or two.
And these are the payments that were being made to the escrow?
Yes, and in fact, that same transaction indicates a high buildup of escrow, which had occurred. The typical escrow for the same due date, April 1st, in the years 2005, 2006, and 2007, was in the $400 to $500 range. On April 1st, 2009, it was in excess of $3,000. So I would say in excess of $3,000 was allocated to escrow, which means that it could not have been allocated to additional monthly payments.
Suspense entry.
Suspense is an entry where if the mortgage company, if there are not enough funds to make a payment, money is put into the suspense account. And in fact, on April 1st, 2009, the suspense account was a very high number, which was just shy of another monthly payment by around $220.57, which meant that with another $220.57, there would have been enough money there to have made
a payment,
the May 1st, 2009 payment. And then the third issue in the case is, and this all arose because the 2007 school taxes were paid late by the plaintiff, and they were paid so late that they were rolled into the 2009 town and county taxes, which brought the 2009 town and county taxes very, very high, $5,500 and something, which meant they made a double payment of those school taxes, and the initial part of the double payment was eventually refunded. But meanwhile, the defendant's monthly payments increased tremendously during that period of time, from what was a stable around $1,500 to about $2,000, and then it got reduced a little bit to $1,800 and something for about 6 months, and that resulting in a that basically was a major factor in the buildup of excess escrow.
You should begin to wrap up, sir.
Yeah. Thank you, Your Honor.
Thank you.
Good morning, Your Honors. Leah Jacob from Greenberg Traurig on behalf of Respondent Bank of New York Mellon as trustee. A variety of issues were addressed in our respondent brief, but I'll try to focus on the issues that appellant addressed in his argument. It's undisputed in this foreclosure action that the loan has been in default since April of 2009. The affidavit of indebtedness that plaintiff submitted in the trial court in its motion for summary judgment established defendant's defaults, and the defendant's arguments regarding misallocation of funds were conclusory and unsubstantiated. Specifically, addressing the argument that the affidavit is hearsay, we submit that the affidavit was not hearsay and it fully complied with the business records exception under CPLR 4518. We had an affidavit from a contract management coordinator who testified based on his personal knowledge of the facts in the affidavit, which were based on his review of the business records. He also testified that the business records documented transactions that were related to the loan at or near the time of the transaction.
So you're saying the business records weren't necessary to be attached to the affidavit, that he's reviewed them, he's indicated he's reviewed them, and that's enough?
He did attach the notice of default to the affidavit, and he also attested to the loan documents and that the last payment was applied to the March 1, 2009 installment, and therefore defendant is in default. And this very court has relied on the exact same affidavits, which attest to the defaults, attest to the loan documents, and attach the notice of defaults to two cases, Citigroup versus Koplowitz, 147 AD3D 1014, U.S. Bank versus Saravan, 146 AD3D 1010. And the affidavit submitted by the contract management coordinator in the trial court was more than sufficient to satisfy the business records exception and attest to the defendant's defaults. And I'll get to the next issue regarding payment number 92, which appellant describes in the loan transaction history. First, I want to note to the court that the loan transaction history and the March 2009 letter from the loan servicer that appellant relies on heavily were introduced in his cross motion for summary judgment in the trial court. The payment 92, even if it was made, you can tell from the transaction itself it was made in May. The loan had already been in default from the April 1st payment. Even if there was a payment made, it wasn't made until May pursuant to the transaction history. And a mortgagee is not required to accept late payments, is not required to accept partial payments, and has been held by this court.
Essentially, the April payment was applied to the March requirement, and the May payment was applied to the April overdue requirement.
Right. If there was a payment made, it was applied to the unpaid installments, and it wouldn't have been applied to the current due date because the loan was already in default. And based on the letter that defendant submitted in his cross motion for summary judgment, it's clear that there was a history starting in November 2008 of the defendant making partial payments on the loan. And you know, the law is clear from this very court that if a borrower is in default, even for one day, a mortgagee may accelerate the loan and is not required to accept a tender of less than the full amount due. First Fed Savings Bank versus Medora, 264 AD 2D 407.
What about the problem with the school taxes?
With regard to the school taxes, the letter again from March 2009 makes clear that there was a refund issued to the defendant's account for those school taxes.
But in the meantime, had his payment ballooned because you changed his escrow?
There's no evidence of there is no evidence in the record that is why his payment ballooned. And with regard to the tax penalties, there's no evidence in the record that the tax penalties were even charged to defendant's account.
Okay, counsel. I
Thank
think we
you.
have your argument. Case 1414, Van Jones versus Jones. Excuse me, Van Loan versus Jones. Deemed submitted. Case 1415, Preston versus Castle Point LLC.
Morning, Your Honors.
Good morning,
Police Court. On behalf of plaintiff Donald Preston, I submit that the trial court erred in granting summary judgment dismissing the complaint in this wrongful death action because defendant failed to establish prima facie its entitlement to summary judgment, and alternatively that in any event plaintiff raised triable questions of fact as to whether the property in question was reasonably safe under all of the attendant circumstances. In his bill of particulars, plaintiff alleged that the defendant was negligent in particular in maintaining this open, unguarded pond on the premises of its senior living community. This was a man-made pond.
It was a senior living community, but certainly there was no duty to supervise these people. They were on their own. Correct?
We had alleged a failure to supervise. The trial court addressed that. I have not re-raised that issue on appeal because candidly it is not an assisted living facility. We acknowledge that. But the question of whether there is a duty to supervise the conduct of these residents is distinct from the question of whether there was a violation excuse me, of the common law duty to maintain a reasonably safe premises.
You're saying that they had noticed that this, the seed would go down there, would feed the ducks, I think?
Yes.
Sit on the bench, which was close to the water, and that notice played a part in their duty to make sure that that was a safe environment for him to do that?
Yes, because they knew that the residents were 65 on up. The decedent was 96 years old at the time he fell into the pond. He had
But there was a gate thing in that they had to climb over or go under to get there. The bench wasn't by the pond. There was a dilapidated bench that no one could sit on. The only bench was up in the parking lot.
Well, and I'm not contending that he even used the bench this day, but it's clear that what he did do, as he had done in the past, other residents had done in the past, is walk around, and it's not really a gate, it's a rail of the type that you'd see, say, in a park that basically separates the roadway, the driveway that he crossed over from the grass that leads about, 7-8 feet away, it appears from the pictures, down to this pond. And it was known that he would go there and smoke. It was known that he would go there, feed the ducks, that other residents would go there and feed the ducks.
What are you suggesting they should have done around that pond?
I think it could easily and should have been fenced off in such a way that there might be access with a deck, with a railing, so that residents could stand there, look at the pond, feed the ducks, and yet not have to walk down this slope which led down from the road to the pond. And I would note that the defendant's program director, Cynthia Caprio, and I think this is significant, said that although the residents could go down there, if she saw them there, she would encourage them to move away because they are so unsteady on their feet that something could happen. So the defendant, by its program director, was certainly aware that people went there and that it posed a risk because we are, as I said, dealing with people elderly people up to age 96, such as the decedent.
Well, we also have another problem here, is we're not even sure how he died.
Well, I think we do know how he died because in moving for summary judgment, the defendant itself submitted an evidence, the death certificate, the medical examiner's report, both of which indicated...
That was without the benefit of an autopsy, however.
Pardon me?
That was without the benefit of an autopsy, however.
There was no autopsy, but still there was a determination in each that he died primary cause of drowning with secondary cause of being arteriosclerotic disease, I believe. But we certainly do have a finding of drowning, and that in itself is prima facie proof that basically creates a presumption of the cause of death. And in the affidavit of their defendant, Dr. Ozar, he thought that the determination was shaky, I believe was his word. But he certainly didn't refute it as a matter of law. So I think on this finding, or on this record, a finder of fact could readily determine that Mr. Preston died solely because he fell from the edge of the pond into the water and drowned, just as the death certificate said.
The death certificate may get you over the hurdle for purposes of summary judgment motion, but the real question we have is what's the duty of the premises owners relative to the guarding of that body of water under these circumstances?
And the circumstances, I submit, are dictated by the identities and attributes, personal physical attributes of the foreseeable users. And this was a man-made pond located maybe 50 feet from the side door of this senior living facility. They were aware that the senior residents would go there. They were aware that they have ambulatory
and all of that awareness,
problems.
all of that knowledge left them with an obligation to protect the people that were going to be using the premises.
Regardless of whether they had a duty to supervise them on a day-to-day basis as you would in a nursing home.
There's at least a question of fact for a jury to determine.
That is our argument, Your Honor. Thank you.
Thank you, Counsel.
Good morning. May it please the court, my name is Jacqueline Mandel. I represent the defendants in this case. The order of the court below should be affirmed because the defendants satisfied any duty it may have owed to keep their premises in safe condition. There is no evidence before you, and there's just nothing in this record to establish there was anything wrong with this pond. In fact, the plaintiff's own expert, if you look at page 803 of the record, tells you that ponds of this nature are typically used as a means of addressing municipal stormwater requirements. You have to have ponds on these premises.
Lot, so to speak.
I'm sorry.
Runoff from the parking lot.
You have to have it, right, in all these different corporate parks.
I don't think anybody's arguing about whether you have to have the pond there. The question is, what do you have to do in terms of making it safe? And is the owner of the property duty increased? In other words, do they have more to do if they're on notice that they have elderly people that are going down to the pond area and they're maybe unsteady on their feet? I mean, do they have some obligation with that knowledge to do something to protect against a circumstance such as this?
Well, you know, it's interesting when we were talking about really this person, right, as opposed to the entire population, because this is the person who got hurt. And there is, at page 825 of the record, an affidavit that states that prior to this, there have never been any incidents, despite the elderly population. And this is 65 and older. So Mr. Preston was particularly elderly, but you could be 65 years old and be there, and, you know, I don't know how unsteady you necessarily have to be on your feet. I'm not guessing at the age of any of the people I'm looking at, but it should just be kept in account that there may be people here who would be eligible to live in this facility.
Right here.
I'm going to just let that.
Right.
I'm just going to let that be. But Mr. Preston, as elderly as he was at 96 or 97, there's no question that he didn't have any kind of impaired ability to walk, that he didn't need any kind of assistance, and in fact that he was.
Well, let me ask you this though. I mean, so what if the record reveals that he did have? It was noticeable that he had some ability with his gait and with his balance. What then becomes the duty of the landowner? Is the guarding a fence now required?
No.
Why not?
My position on that is still going to be no, because the pond as it existed was not in a defective condition, and the population, you know, we should really look at the pictures in the record to talk about this, because when you go to where is it, at page 600, I think. If you start at page 600, you see the back door of the residence where Mr. Preston lived. And you get a nice shot right out across the street. You can't even see the pond. You can't even see it. And what you can see as you turn the pages is that to get to this pond, you have to cross a street, and you either have to step over a guardrail, which, I mean, has to be at least 2.5 or 3 feet high, or your alternative is to walk, and you can see this better when you get to page 605.
So you're saying is if we go through the photos, it's going to demonstrate that in order to get to where he was.
You have to do it deliberately.
Yeah, and he had to be agile as you're
You
and
have
able
to
to
be.
walk. To
Wheelchair people are not getting here, right? People with canes and walkers are not getting here on their own. And it's not a place where anybody's invited to go or encouraged to go. Mr. Preston needs a place to smoke, right? There are letters in the record that, you know, he was smoking outside his back door, the 97-year-old man. And he was bothering the other residents because the smoke was getting back inside. So they said, you have to go away from the building to smoke. So he goes to feed the ducks and he goes to the pond to smoke, and he's capable of doing it, and he's been doing it without a problem since he got there in July. We don't know how Mr. Preston got in the water. Nobody knows how Mr. Preston got in the water.
Well, I mean, your opponent argues, though, that the death certificate indicates drowning, and that isn't that enough to, at least for purpose of summary judgment, absent some, you know, it being refuted, that's enough. So the drowning issue, I think, does survive this, but the question really has to do with the duty, I think.
Yes, Your Honor, I think that the ultimate question, before there can be any liability, of course, there has to be a duty, and then there has to be a breach of the duty. And without having any idea of whether he slipped or whether he tripped, he got in the water. We don't know if this 97-year-old man had a stroke or a heart attack, and that's what killed him, and he fell in the water. Nobody knows this because, as Justice Winslow pointed out correctly, there's no autopsy. We don't know why. He is an able-bodied man standing at the side of a pond, feeding ducks and smoking cigarettes. It just doesn't...
I think we have that argument, Counsel.
Thank you, Your Honor.
Thank you. Case 1416, Bigelow versus Hamilton Medical, Inc.
Good morning, Your Honor.
Counsel.
Joseph Spittle for the State Appellants. This case raises an important question about the statutory privilege for a hospital's quality assurance records. The court below ordered the disclosure of all statements made by defendants within the quality assurance process underlying the incident issue.
Do you make a distinction between oral and written statements in your brief?
We don't. No, we make a distinction between statements made during the investigation stage and statements made during the committee meeting stage of the quality assurance process. So there's no question that written statements, for example, if a doctor takes notes during the committee meeting, this court has held that that is subject to disclosure.
Okay, so you don't make a distinction between oral or written. What if after the QA meeting, and let's assume maybe there's going to be more than one, who knows, but after the QA meeting, the doctor is then interviewed by the QA investigator, research, whatever. Is that discoverable after the meeting, orally?
It would depend on the context, but if that's in the context of a meeting, if it's the functional equivalent of a statement made before the committee.
But where does the functional equivalent language come from in the statute? It says in attendance at a meeting, and you want us to strictly construe it, correct?
Correct. Well, the functional equivalent language comes from this court's decision in Schwarzenberg.
So you agree that Schwarzenberg was a departure from the strict interpretation of the statute with respect to in attendance at a meeting, correct?
Correct.
You say so at page 15 of your brief.
That's correct. And under the circumstances of that case, it was a reasonable departure from the language.
Do we need to disavow Schwarzenberg in order to grant you the relief you're seeking?
No, you don't need to disavow Schwarzenberg. You need to simply distinguish it from this case. Or
what's the distinction?
Well,
after the meeting, in writing, orally, contemporaneous, none of that's in the statute, right?
What's in the statute, Your Honor, is the statement in attendance at a meeting. The statute requires that it be during a meeting. Now, in Schwarzenberg, this court made a narrow...
Schwarzenberg was after the meeting, correct?
Correct.
And it was therefore not in attendance at a meeting, right?
Correct. But it was in response, it was as if the committee had called up the doctor during the meeting and asked him to explain his conduct. Is that attendance? Well, it's attendance.
Why isn't it any different when a researcher goes out and says to somebody after the fact, hey, what happened? And aren't those recollections of the parties that much better because they're sooner?
Precisely, Your Honor, and that's why the legislature sought to protect those statements. Because the information provided to an investigator hours after the event. Remember, it's like the difference between making a statement to police investigators on the morning of a crime and testifying at a criminal trial.
But there's nothing, what I'm troubled by is there's nothing, you want us to have a strict interpretation. There's nothing in the statute that says contemporaneous is to be protected and later on is not. It says in attendance at a meeting. That's what I'm really stuck on. I'm buying your argument maybe, but then I don't see how you can say that something comes up afterwards in a letter, orally, whatever, is within the exception to the privilege.
Well, again, attendance is the word. I think attendance at a meeting. The statute clearly limits disclosure to statements made by persons at that meeting. And the Schwarzenberg case was a slight departure from the case, from that language, in a situation where it was essentially the same as appearing before the committee, because the committee had actually issued a memorandum asking the doctor to explain himself.
So you'd be okay with the rule that says if it's essentially the same as being in attendance at a meeting?
Yes, that's what Schwarzenberg said. I mean, if the court has trouble with the Schwarzenberg decision, I think the reasonable minds could disagree with Schwarzenberg. Because the statute says attendance. Attendance doesn't mean writing a letter. In the English language, if you say, I submitted a letter, but I didn't attend the meeting, we wouldn't understand that as a form of attendance. So the court could say Schwarzenberg was wrong, or it could simply limit it to the circumstances of that case.
So can we frustrate the exception contained in the statute? If the hospitals utilize a person, I'll call it a liaison, like Nurse Gleason was in this case, I think that's who it was. Everyone was reporting to her.
Correct.
And she was kind of the conduit to the Quality Assurance Committee.
Correct.
I mean, if that mechanism were used on a regular basis, wouldn't that essentially defeat or frustrate the statutory exception?
No, Your Honor, because the medical professionals have a self-interested motive for appearing at these meetings and defending what they did, as the doctor in Schwarzenberg did. In other words, if the doctor wants to go to the committee and say, look, what I did was proper, consistent with the standard of care, then they can do that, but they're on notice that those statements, which are a form of self-advocacy, are subject to disclosure.
What if it's on the other side, the doctor's a little concerned about what he did?
Well, then he has no obligation to show up at the meeting. And again, this framework was designed to protect the quality assurance process and ensure that hospitals could improve the quality of care. It wasn't designed to create a trove of information for malpractice plaintiffs. And that's why the exception is so limited.
Would you agree that those, I think it's second department cases that go the other way, right? Their derivation is from Schwarzenberg.
The language they cite comes from Schwarzenberg. However, those cases are not on point because they don't even address the question at issue here. I submitted the briefs as part of my reply brief. The defendants actually didn't even raise an objection on the basis that the individuals were not in attendance at the meeting. Those cases involved completely different issues. In one case, it was about whether one of the individuals was even an employee of the hospital. So those cases have dicta that suggest a broader reading of the statute, but that's just inconsistent with the plain language of the statute.
In your research, sir, did you find a case of ours called Brian?
I'm not familiar with it off the top of my head.
Brian? I didn't think anybody cited it. Okay, thank you.
I'd just like to make one last point, Your Honors, which is that this privilege does not prevent plaintiff from using all the tools of discovery to find out what happened during this incident. They can and have deposed all the relevant players, ask all the questions they want about what happened that night, but what they can't do is get the information that the hospital gathered as part of its internal investigation, because that's for the purpose of improving the quality of care and not for the purpose of allowing malpractice plaintiffs.
And that was the point of the legislation. The legislation was to encourage that kind of disclosure in this process so that they could provide better health care going forward.
That's correct. And also to actually reduce malpractice insurance premiums, which were so high at the time that they were unaffordable. So the intent was clearly not to create more information for malpractice plaintiffs. Thank you, Your Honor.
Thank you, Counsel.
Morning, Your Honors. John Chirundolo Law Firm on behalf of the infant plaintiff in this case. We believe that Schwarzenberg carries the day in this case. I think Schwarzenberg lays it out very clearly that if there's a statement made in the course of the quality assurance investigation, that should be made known, particularly if the defendant now is a defendant in the Supreme Court case.
That was a request that came directly from the committee, as opposed to the statements that we're talking about here that were made to an individual named Gleason.
She was the committee, yeah. She is the quality assurance person at the hospital. So she went out and apparently in an attempt to defeat the Schwarzenberg request, did it in this fashion so that she went out and took oral statements from these people and wrote the statements down, and then she submitted them to the Quality Assurance Committee. So
what's the difference between a letter sent by the doctor after the meeting and a statement given more contemporaneously before the meeting to an investigator? Can you give me a distinction so that if we want to say that Schwarzenberg is distinguishable, how would we do that?
I don't think Schwarzenberg is this. In all honesty, Judge, I think that if there's information that is sought out by the committee, and that information is given and then used at the committee, whether it's before or after, I don't think there is a distinction. And I think this court in Drum in May of this year, with the PowerPoint that was made before the committee and submitted at the committee, I think that even goes further to show that in this particular case that this is something that gives life under the exception in the statute.
But didn't Drum, the physician was there. It was the nature of the presentation, this PowerPoint issue, but he was present at
He was there.
He was there.
He was there.
Okay.
In this particular case, I don't know whether these people were there or not. I mean, 3 of them had said they weren't. Holly Payne, I guess, didn't remember what the situation was that she did it in. Holly Payne really is the pulmonary therapist that was at the machine when this event happened with this young child. So what she says is very, very important in the overall circumstances. And going back, our initial requests were that they didn't give any such statements to the committee. We find out in the deposition that Holly Payne, in fact, did give statements to the committee, and that those statements were presented by the Quality Assurance Director. So I think we should be entitled to the statements.
Thank you, Counsel.
Thank you.
Case 1417, Benedict versus Benedict.
Good morning, Your Honors. May it please the Court, my name is Tim Benedict. I'm the defendant appellant in this matter. Jumping to the points.
Mr. Benedict?
Yes.
Good morning, sir. As I see the briefs here in the record, it looks to me like your 2 primary points, I don't mean to boil it down too much if I am, but your 2 primary points would be custody/visitation and imputation of income.
Correct.
Okay.
I would agree 100% with that, Your Honor.
So, do I have right, you didn't give us the benefit of a reply brief?
That's correct.
So is it fair to say that we can take as true the facts recounted in the respondent's brief at pages 5 to 10? I think how they got that list of 21, and each one of those facts they've tied to a portion of the record. So we should accept those facts as accurate, correct?
I would disagree with that, Your Honor.
Why?
I believe that the facts that I presented in my brief, as well as the contents of the record, to some extent call into question the complete accuracy of those statements.
But if we trace those points at pages 5 to 10 of the respondent's brief to the record and we confirm that they're in there, you wouldn't be able to dispute them, correct?
Well, with regard to, do you have a particular component that you want to inquire
pages
about?
Pages 5 to 10 has a list of 21 facts that are set forth. Each one appears to be tied to the record, and then I don't see a counter statement of facts anywhere that refutes those facts. So that's where I'm stuck on.
Okay. Well, again, Your Honor, with regard to the reply brief, I do run a solo practicing firm, so I may not have submitted a reply brief, but I don't think that those statements should be taken as completely accurate, especially in light of my positions to the contrary.
We'll take that under consideration, counsel. Why don't you proceed with your argument?
I appreciate that. With regard to the custody argument, as Your Honor indicated, I believe the facts indicate that the relationship between myself and the plaintiff was not so acrimonious as to preclude a joint custody arrangement in this case. I think specifically this court, including Your Honor, Justice Whalen and Justice Smith have in the past found that where there is some disagreement or some discord, as long as the parties are able to make decisions with regard to the child or children's best interest, that joint legal custody is still tenable. In this particular matter, the record shows that the child in question, he had several issues with regard to medical problems as well as an educational need. There was an IEP with the particular school district. Both myself and the plaintiff did attend that. We were able to make decisions as far as the schooling, specifically his speech issue. In addition to that, there was testimony that we were able to make decisions regarding the child's best interest as far as medical is concerned. In fact, I would point out that, as indicated in my brief, and the record bears out that during trial, ma'am testified that we were able to civilly and amicably discuss and make decisions regarding education and medical issues. Her specific testimony from, I believe, June of 2015 was that...
Well, you'd agree that in us searching this record, we're not going to find the two of you agreeing and getting along. That's not what your argument is. You're saying that there were periods of time when that occurred, but that you're certainly not arguing to us that it was all very amiable and everybody got along.
What I'm arguing, my next point was going to be that as of June of 2015, ma'am had indicated that the last issue of discord between us was December of 2014. So by the time that the final hearing date was in place was April of 2016, we had nearly 2 years of it not having any particular issues. So I would really say from December 2014 forward, for all intents and purposes, things went well. There was a specific issue.
That doesn't cure all the acrimony that went on before that, right? I mean,
no, it goes both ways, and certainly I think the Fiorelli case, which this court held that during the in the context and the progression of the particular divorce proceeding, the relationship improved to the point that joint legal custody became more tenable. Certainly both parties in this particular matter, as the record bears out, I think had some responsibility for the discord. But certainly from December 14th to the final date of the hearing, we were able to make decisions in child's best interest. With that being said, I think, well, again, it wasn't all, bowl of cherries, but certainly we had progressed to the point that we were able to make decisions, and certainly, it's not in the record, but nothing's changed since that point. So with that being said, the two issues that the lower court seemed to have regarding the child's best interest between myself and the plaintiff were what I referred to kind of tongue-in-cheek were oral fixation issues. We had issue with use of a binky or a pacifier and use of a bottle at our respective homes. That, by and large, had resolved itself by the time of the last hearing. That's not something that we need to deal with at this point, certainly going forward. But the extent to which, and I said it again, tongue-in-cheek, those types of things could be appropriate for a sphere of influence type of decision. But by and large, the medical and educational issues we have and continue to make decisions that are in the child's best interest, no issue. The other thing that the lower court seemed to really put some weight on was testimony from a former relationship with whom I have a child in common. There was an issue where our child, unrelated to myself and plaintiff, had a need to go to he had a conversion issue. It's a psychosomatic type of matter. There was a meeting in Philadelphia. I had disagreed with the appropriate way to handle that particular matter. I thought we should do it locally. She took the position that it should be seen by the Children's Hospital of Philadelphia. We had a disagreement. We moved on. Nothing was done as far as, to prevent that type of that therapy with regard to that child. Now, what the court, I think, failed to acknowledge, at least as the record bears out, that as between myself and Ms. Bowman, the other party, we had gotten along. I had gone to dinners with that person. We had celebrated birthdays together. I had hung out with them, her and her current husband at various activities and extracurricular activities. So to really focus on one issue taken out of the context of the complete testimony, I think is a bit.
Sir, we'll take a look at the record and we'll drill down on that. Do you want to reach the imputed income issue?
With regard to the imputed income, again, this is not a case where there was no discovery had or given.
You agree some imputation was appropriate. You just disagree with the differential, that is the amount.
I agree with that. Right.
I think the relief that I think you're asking there is you want the case remanded to family court so they can review your tax returns that have been filed in the interim.
Correct.
When did you file your tax returns?
For the 2015 tax year, I filed in October 2016. 2016 would have been filed in October of 17.
Okay, so these were not available.
Correct.
Well,
correct.
But had you filed them timely, the court would have had them?
I had filed an extension timely in both cases. I did provide the court.
Okay, but the court had the best information, didn't have tax returns.
It did not have tax returns.
So they had to resort to other information.
It had the fact that I was terminated from my employment with the Corporation Council when the new mayor came in, but I did provide 1099s.
It's not like they ignored the tax returns. They didn't have them. They weren't available.
Correct.
Okay.
They did have W-2s and 1099s, though. Okay. So again, I think the court understands what the arguments are as far as this point now.
Thank you, counsel.
Thank you.
May it please the court, Clifford Eisen, appearing on behalf of the respondent, Jacqueline Benedict. Your Honors, I'll start with the issue of custody and visitation, and I'll observe the same dichotomy that the court kind of looked to during the appellant's argument. As Justice Curran pointed out aptly, this record is replete with evidence of the appellant's misconduct. I went to great lengths and spent an enormous amount of time combing through this rather voluminous record to get all the evidence that pertained to the appellant's misconduct, a large portion of which was completely uncontroverted at trial. And as Judge McCrae, our trial court judge, pointed out also, a lot of it came from the appellant's own witness in the form of his son, actually two witnesses, where he had testimony from his witnesses, his two older sons, testifying about grabbing them by the throat, one starting when one of the boys was 5, and I think that testimony was that that happened 3 times during his life. I think ages 5, 7, and 13, or somewhere in that age range.
Didn't those children also testify, though, what a great relationship they had with their father?
They did. I would put to the court that puts a child in a very difficult position, especially when I think the testimony also showed that those children resided with the appellant at that point in time. So, and again, when we're evaluating testimony, the testimony put on by the respondent at trial was very poignant, very specific about instances, when they happened, what happened. In opposition, appellant offers us these gross generalizations. Things are good, we generally agree. What's more powerful? Just a gross...
But the specifics, he says, within 2 years of the decision, there really weren't disputes of any meaningful nature.
Well,
do you contest that?
I do. I think the record shows that the disputes continued. I do agree that with appellant's characterization that as of trial there had been about a 6-month reprieve. However, I think the name of the game here when you're talking about custody and visitation determinations is deference to the trial court. And clearly what this trial court has done is discount the behavior of the parties as we approach that day of trial. And as a matter of fact, there were 4 days of trial. So I think the period of time that the appellant's referring to is that period of time between really the second to last and the last day of trial. So I think that was well within the trial court's discretion. I don't think there's no one should really be surprised that there are going to be times when when a parent in the respondent's position tries to get along with the appellant. That doesn't go to show that they can routinely communicate. That just shows, again, that there are few instances where they can get along and communicate. I recounted a fair amount of domestic violence that had occurred, and I don't think any of that was contested or controverted in the record by appellant. Is it any real shock that when the respondent might walk on eggshells in dealing with the appellant, that she's going to avoid upsetting him and triggering this explosive temper that was shown, again, throughout the record? So again, just to summarize that, I think the record's clear. If the court reviews my recitation of the facts.
We'll take a look at it, counsel. Do you want to move on to the second argument?
I do. As to the evidentiary sanctions, it seems that the appellant's primary argument.
Let's just go to the imputation of income. We've got to see whether or not we think the differential that the appellant would say was okay, that is the imputed income, because he doesn't object to it entirely, right? It's just at a certain amount. We've got to look at whether or not we agree with that calculation, right?
Well, how can you really do that in light of the fact that there was this continued refusal to produce the business ledger? What is more clearly indicative of the income of a practice than the business ledger? The tax returns provide some idea. Yes, they do. You can get a general idea, but you can't see everything. And that doesn't go to say that people don't misrepresent things on tax returns. What was specifically requested here, and what the appellant repeatedly refused to give you, were the business ledgers.
This went on for a couple of years, didn't it?
It did, as a matter of fact, and I recounted that in some detail in my brief also, because I think the timeline of that's very important when you start talking.
Your opponent says that, I think, if I understand the record correctly, that a computer system crashed, they were available, he had to recreate them, and so there was some explanation as to why there was a delay in providing these records. Isn't that right?
It is, but I would submit that Judge McCrae took a very deliberate approach to allow the appellant to rectify that. He set up, on a number of occasions, he set up a process that the appellant could work through that problem. The most recent of which was right before trial, when Judge McCrae ordered the production of this computer to a
It would be hard,
computer
based on
expert.
this record, it'd be hard to say that Judge McCrae wasn't incredibly patient in dealing with this issue between the parties. Yeah, I wouldn't disagree with you in that regard. Okay, why don't you move on?
Okay, and so essentially, just to I guess tie a ribbon on that argument, when you get this repeated willful failure, you're going to get a sound basis in the record for 3126 sanctions, and it should not be left to the appellant to pick and choose what items of discovery he will or will not give to the other side. And then with regard to the imputation of income specifically, Judge McCrae goes through really a three-scenario analysis of what's really the best and fairest way to arrive at income. And again, on the issue of imputation, the court has considerable discretion to impute. He just needs a reasonable basis to make whichever determination of the appellant's income that the judge thought was most fair and accurate. And I would submit that the court's decision is very clear on that. And unless the court has any other questions, I'll rest on my brief.
Thank you, counsel.
Thank you.
There's no rebuttal. Case 1418 and 1490, Celino versus Celino and Barnes. Counsel, before we begin, I would note that you each have asked for 30 minutes for argument. I know you can fill that time very easily.
We're not going to need it, Judge.
Yeah, I think that the issues in this case are relatively straightforward, and so I would suggest that you can hit them with much less time than that.
Yes, Your Honor, and it's we're taking an appeal here from two decisions. I'm going to focus my argument on the decision of the court below that denied our motion for summary judgment to dismiss this petition. Here the record establishes as a matter of law that the alleged deadlock and dissension between Messrs. Salino and Barnes has not precluded the successful and profitable conduct of the corporation's affairs. That is indisputable in the record before the court, and itself is dispositive of this proceeding. Second, the record also establishes here, as a matter of law, that dissolution would not be beneficial to Salino and Barnes in their capacities as shareholders. That's a second dispositive reason where the court's decision below should be reversed as a matter of law.
Good
yes.
morning, sir.
Good morning, Judge.
1104A1, right? That the directors are so divided respecting the management of the corporation's affairs that the votes required for action by the board cannot be obtained. That would be true with respect to a number of issues, correct, on this record?
It is true with respect to, well, there's never been a, quote, directors meeting requested until after this lawsuit.
So they can't even agree to hold one?
They've had multiple meetings, and one could call them directors meetings, but the only actual notice of a directors meeting came after the lawsuit. Put that aside, Judge. They do not agree on a number of issues. The governing and key point is that a disagreement among the board on X issue or Y issue in and of itself is insufficient as a matter of law to grant an 1104 petition. The deadlock among directors must also prove that as a result of the paralysis, the corporation cannot effectively function or manage. And
well,
that, on this record, is
indisputable. If one person just takes control of it and runs it.
The reason, Judge, for, that's Mr. Salino's allegation. The reason for a disagreement, or the reason for a deadlock, or the reason for, as he claims, he's been ostracized, as distinguished from what Barnes says, which is he absented himself. Put the reason aside, because in an 1104 action, the reason is irrelevant. There is a statutory remedy for a shareholder who claims he has been ousted from the management, and that is 1104-A.
Under which Mr. Barnes could potentially elect to purchase.
Yes, absolutely. And in fact, if you look at the majority of the allegations in the petition before this court, most of them have to do with Mr. Salino's disappointment or disagreement with proposed changes to the future, as distinguished from disagreeing with how things had been run in the past. And he says that he wanted a more active role. He wanted to explore a different advertising. He wanted to do X, Y, or Z. He objected about California. Those things do not and have not prevented the successful functioning of this corporation. And
well, your opponent, I think, would argue to the contrary and say that, you know, if it had been run as a partnership with both input, that it would have done better.
Perhaps, but that's speculation. There is no need for a hearing in that regard, and the Glamorous case that we cite in our brief is exactly on that point. It is impossible to know whether it would be done better. What we do know is, as we stand before you today, this firm is extraordinarily successful. And whether it could have been better is not a ground to dissolve and destroy that which has been built up. The Klein case, which... Yes, Judge.
The contrary also is present. Dissolution should not be denied simply because the business is profitable.
That's true as a matter of statute, but this case before you involves much more than a business that is, quote, merely profitable. It has taken these two gentlemen from Buffalo 25 years to build one of the most successful, profitable law firms in personal injury in the country. I know you're all familiar with the record on their profits, $1 million a year, but they've got 5 offices. $1 million a month. I misspoke. I misspoke. You know, and in the Klein case, which is directly analogous, there it also was an advertising law firm. We have more in this case than simply 2 lawyers who are diverging in their views of how they want to practice. This is a firm that has been built on advertising. There are 56 lawyers. There are 237 employees. The lawyers make extraordinarily good salaries, like in Buffalo, more than $300,000 a year, which is outstanding. They have substantial goodwill. There is a unique presence of appellate counsel, networks with experts. Each office, of which there are 5, each has a managing attorney. The day-to-day business of this law firm is indeed functioning, and that is beyond question. Whether Mr. Salino wants to continue to practice as a co-shareholder with Mr. Barnes, he's not obligated to. But what the law does not permit is for him to destroy the firm. You know, one of the leading cases on dissolution, even though it's an older one, is Justice Desmond's decision in the Radon case, which has been cited by approval by this 4th Department in the Sheridan, another case cited by Mr. Salino. And the Radon case made it very clear that dissolution under 1104 is that was before 1104, but that dissolution is a last resort. And while there may be serious disagreements among the principals, you do not destroy the firm in order to solve the deadlock so long as the firm can function. The key question is, will dissolution be to the benefit of the shareholders?
And you say there's no question of fact that requires any kind of a hearing or moving forward?
Not on benefit to the shareholders and not on the functionality. On the functionality, clearly dispositively not. This firm, I know in their brief at page 2, they say this is a firm in peril. If only every law firm could be in such peril as this one. What these 2 gentlemen have accomplished is extraordinary. Aside from the income they're getting as shareholders, they have built a brand, and it's uncontested in the record that the value of the Salino and Barnes brand, which include the phone numbers, the jingle, built by years and millions and millions and millions of advertising over the years, is worth $40 million alone.
Let me ask you a question about the brand issue that was raised. There was a period of time when the name changed and it became the Barnes firm.
Yes.
And there doesn't appear to be any type of diminution in the growth of the firm after that, or that was somehow even a speed bump in their remarkable growth. We now have a Barnes firm, the LLC, out in California. That is not a Salino and Barnes in terms of the branding, because the branding is a lot with respect to the name, isn't it?
The brand, yes, and it's not just the name.
It's not just the name.
It's clearly not.
Would you agree it's a major component of the branding?
The name is a component, but in California, they don't even use photographs and pictures of the 2 principals. What is the key is the phone numbers, the jingle, and the familiarity with both names, whether it be Salino or Barnes, and that's what draws the clients. Interestingly, and of particular relevance, I submit to the court, is that this petition was filed 18 months ago in May of 2017. In the ensuing 18 months, there has been an increase, not a decrease, in not just shareholder profits, which are on record levels, even compared to before the dissolution, but in client intake, in total settlements, which is a great benefit to the client.
So we're talking about, you're focusing, as you have in your brief, with respect to, the value, the generation of income and the success of the firm. But what about the governance issues when it comes to a lack of trust, which your opponent points out, and the idea that one partner believes the other partner may be taking cases away from the Salino and Barnes, Salino and Barnes, the PC, and shifting it to the LLC. And doesn't a breach such as that cause problems for partnership to continue?
Judge, a breach such as that would cause a problem. It is not necessarily at all going to satisfy the BCL 1104 standard, which requires that the corporation not be able to continue to function, which they cannot prove, and there's no evidence in the record that that doesn't prove. And the dissolution would...
But you'd be saying, I mean, assuming the allegation is that, let me finish,
yeah.
Mr. Porteous. You're assuming that if that allegation was true, in other words, that there were cases being taken away from the PC to the LLC, you're saying that, well, the PC can continue to operate, but maybe, and maybe irreparably, because it'd be hard to track, that those cases are gone. And how do we know that's not happening?
Well, let me respond on 2 points to that, Judge. All of those allegations have to do with the California firm, which I'm going to refer to here as the LC. Subsequent to the filing of the petition, Barnes, because in part the petition was so replete with allegations concerning alleged conflicts with respect to the California firm, even though we disagreed with those, in order to alleviate and remove any issue or concern with respect to California, Barnes made the affirmative decision to completely separate the two, and that was done. And that's also in the record in front primarily of the adjacent motion for the receiver. So as a factual matter, there is no and has been no ongoing potential conflict, and there's no need for a hearing in that regard either. The court below, as this panel is aware, I know appointed a receiver to, quote, oversee the separation of the two, not to determine whether there's any ongoing conflict. So in regards to the issues raised by the petition, they've been addressed. It's not like Mr. Barnes said, Mr. Salino, I disagree, you're dead wrong, I'm going to continue doing whatever I want to do with California. He didn't do that, Judge. That's just another example of how these two can, in fact, continue as co-shareholders.
Who's going to decide hiring and firing? Who's going to decide marketing?
They do that on consensus. They have always done it on consensus, and it continues to be done. I know that there's an allegation that...
That wasn't done with my question, Mr. Fortas. Not just hiring and firing, marketing strategies, whether or not to team up with other firms. You say that by consensus, but the record at least raises a trial question of fact as to who's running the firm now, right?
I think it would be fair to say that Mr. Barnes is in charge of the day-to-day business activities. He is the president, and he has been, in fact, doing that ever since the Barnes firm, which goes back to Your Honor's question back in 2005, I think it was, or something like that. He has continued to, but don't forget, this firm has 5 managing lawyers. All the ads that you currently still see, they were all done on consensus. There's Mr. Salino and Mr. Barnes in every one of those ads. If Mr. Salino wants a different ad, all he's got to do is sit down with Mr. Barnes and talk about it.
Well, all he's got to do is that. That sounds like that's the biggest problem. They can't just sit down and do that.
Well, if they don't agree, that's not a reason to destroy and dissolve the firm, is my point. This is an 1104 action. He has a separate remedy if he really wants to do his own thing. And I think the court should bear that in mind.
Your point is, as president, he's obligated to undertake the duties of the president, and that is the day-to-day operations of the firm, and that's something that is ongoing, and he's fulfilling his obligation.
Absolutely. And don't forget, this is a attorney who left one of the big firms in the early 90s, volunteered for the Iraq War, served in the Marines, came back, and got together with Mr. Salino, and they started what was initially a partnership, and then in '98 became a professional corporation. He has put his heart, soul, and hard work into helping build this outstanding firm for the last 25 years. When Mr. Salino, and he's been the driving force behind it, at least for the last 10. When Mr. Salino says
Mr. Porteous, let me say this though. Really, what you're just saying is that there's no need for a hearing. We get that argument, and Judge Chimes disagreed. She said there's a number of factual issues that have to be resolved. and we understand that point.
Okay. With respect then to the receiver point, the receiver should not have been appointed because there is no evidence that irreparable harm would result. And unless the courts have any questions about that, I'll stand on our authorities in the brief with that respect.
Thank you, sir.
Right, thank you.
May it please the court, and good afternoon. My name is Terry Connors, and I will speak for Ross Salino throughout the course of these proceedings. I'm happy to stand here and explain to you the disputed issues of fact that deny the opportunity for the respondent to have a summary judgment on these proceedings. I'm happy to talk about that, about the fractured trust, about the loss of confidence, the fidelity and the loyalty that has all been breached, about a firm that's gone astray for the last 4 or 5 years where they can't even decide how they talk to each other. They talk to each other through emails. They talk to each other through lawyers. There's no trust here, and that's the essential part. That's what makes us unique as lawyers, the fact that we trust each other and we cooperate. And I'm happy to talk about that throughout my time that I'm available. But we don't even have to reach that. Because Justice Chines has said, this is a very serious proceeding to break up this law firm. I think I need some evidence. I have a discretionary right under the Business Corporation Law, Section 1109, to order a hearing. Frankly, there was a large portion of our strategy. We thought we would move for summary judgment ourselves because it's laid out so clearly. If you look at the emails over the period of 3 years that they never even contest, concluding with the March 10th, 2017 email, where Barnes says, it's clear and obvious that we have very difficult differences of opinion, that we may never be able to work out. That's what their side says, not what we say. And the judge says, well, let's have a hearing. We thought that's what she would say if we sought summary judgment under the circumstances. And that's why we refrained from seeking summary judgment, because there has to be a hearing. There are so many disputed facts. This case is replete with 267 allegations in the verified petition, 297 allegations in Ross's affidavit, and the response is over 400 sworn statements where they dispute what we have to say. And the fact is, many of these sworn statements are demonstrably false. When Steve Barnes says Ross never wanted to be involved in the corporation, and we show him instances where not only did he want to be involved, but he proposed this division. He even asked to be president. They're just flat out wrong that he hasn't asked that. And he's been rebuffed, flatly rejected, sometimes in minutes, sometimes in hours, and told basically, if you want to communicate with me, send me an email or have your lawyer call me. What law firm functions like that? And you know, there's a difference. We are criticized below because our briefs talked about the fact that we characterize the relationship as a partnership when it's a corporation. I know it's a corporation, but the case law that's been decided on these issues, especially with respect to law firms, because we are unique, we are a personal service corporation that relies upon trust. Those cases say, I didn't make this up, it's more akin to a partnership. And when it's a closely held corporation, and here it's co-equal owners, closely held, that's when it's interpreted just like you would a partnership.
Mr. Connors, you'd agree, though, that your opponent's right when they say this is a drastic resolution of a disagreement, right? And this is really the last ditch effort that should be undertaken here. And we are looking at a partnership, a firm that is incredibly successful. And over a long period of time. I don't know that there's any dispute about those facts either. How does that come into play with respect to the motion for essentially summary judgment? Although there's a dispute with respect to what the standard is.
Yes. There's two parts to that question, Your Honor. The first part is you pose, is it a last resort drastic remedy? And those are words that are taken from some of the case law. And the second part is it's a successful corporation. and why would you do this? A last resort comes when you've tried everything else. And look at the emails over a period from 2014 to 2017. Ross proposes divisions to keep them together and not have a dissolution. Flatly rejected. Ross is proposing meeting with lawyers. I'm not meeting with any lawyers anymore. I'm tired of talking through lawyers. Look at the affidavit of the senior counsel, the one who is respected enough to have both sides ask him for an affidavit. He says, I've known both of them for 20 years. I'm a colleague of both. You both asked me for affidavits. I declined both of you. But now I'm submitting one because I'm going to give my voice. You think I'm direct, you think I'm candid, you think I'm honest, here it is. Whoever it benefits, it benefits. And what we learned from that affidavit is situations where not only has Ross's efforts to be involved been rebuffed over a 3-year period of time, but a quote from the respondent is, help me mollify him. Help me distract him. I'm not letting him participate in the management of this company. It's never going to happen. Never going to happen. That's a quote, and that's in evidence here in the affidavit.
Here's what's bothering me a little bit about this in terms of dissolution, because it is a dramatic, especially if you play this all out and no deal is struck. It's dramatic under dissolution. Assets are sold, you know, it's very bad if it goes to that point. So my question is, given the possibility that might happen, is there anything in any of the documents between these two gentlemen that they agreed upon an exit strategy? I don't see it. I'm not trying to set you up.
No, I know, Your Honor.
There's no buy-sell agreement. There's in the bylaws, there's a provision that if you want to retire or if you die, right, you can get out, obviously. Yeah. But other than that, it seems to me that what they essentially agreed to, by at least by implication, was an involuntary breakup.
There are, that's in large measure true, but there
but
are...
That's got to be totally out of the realm of possibility, right? These folks are way too smart, way too successful to let the A-bomb go off. So
there are some provisions, excuse me.
My ultimate question, it's okay. You didn't quite stop on a dime like Judge Villardo, but not bad. In any event, my question also boils down to, why didn't you do an 1104A like Mr. Furiatis suggests?
Well,
that's the exit strategy, right?
First of all, to answer your question initially, there are some provisions, contractual provisions that provide for a buyout. Right? But the reason we didn't do an 1104A is really quite simple. That in effect constitutes a walk away by Ross because the other shareholder has the opportunity then to buy him out. And what he does is, this is his father's company that he put together. He has a substantial investment in this particular firm as well. Why should he walk away when he's allowed under 1104A1 and 3 the opportunity for dissolution? That's a statutory right that he has. Why should he forego that? And you know from the case law that's been decided, they don't permit you to convert 1104A.
So he would prefer to have the firm be dissolved, the draconian result. He'd prefer to have that A-bomb go off than to be bought out. Is that what you're telling us?
A dissolution is not always an A-bomb, and I know from Pennapint and the other cases involved that there are some provisions, but it can be an orderly process. And it presents each shareholder with the opportunity to retain certain aspects of the firm, to buy certain valuable entities, like the phone numbers, you know, like the infrastructure, things of that nature. So it can be done in an orderly process. But Judge, think about this. When you have been faced with this type of frustration for a number of years, your sole objective is to dissolve the corporation and to start anew, to run a firm like you want to run the firm the right way. You've seen the divide they have. Their perceptions of a law firm are as bifurcated as a serpent's tongue. They don't agree on anything, whether it's the odious practice of disbursements to clients. Think about that. One doesn't want to do that. The other wants to do that. From the hiring and firing you posed earlier, they can't agree on it. The only reason it's happened now is they're under a status quo order. And the only reason it happened before, when it was during the 2 or 3 month period of this frustration, is because at times Ross didn't want to blow up the firm. Didn't want the A-bomb, as you put it. He tried everything else, and that's why this is the appropriate remedy now, because we have hit the last resort, Your Honor. This is the only thing that can happen. But the fallacy of their argument is there's no questions of fact. That's absurd. You've seen the documents, you've seen the pleadings, it's stacked up on your desk. And the Ricci case governs that. That's right here from the Fourth Department. It said in 1985 or 86, it would be an abuse of discretion under 1109 not to order a hearing under these circumstances. We, as I said, thought there was no need for a hearing, but we stepped back and said that's unrealistic, unrealistic. So the issues now, they make an issue as to whether it's effectively functioning, because they make a lot of money. Because they make $1 million a month, that's the end all. As you pointed out, Justice, that's not what the statute says, and profitability has never been the metric that determines whether or not you're effective. It may go into the calculus, but it's never been the important metric. And you know, all of us practice law. We know for first-hand basis that being a lawyer is much more than checking out how much you have in your bank accounts or looking at your possessions. It's about what you can do for people and how you go about doing that. And Ross can't do that anymore because he has a co-equal partner that it is laughable that his co-equal partner dismisses everything he has to say, flatly rejects it with no alternative. They can't agree on the COO. Now that's a title that is sort of de facto as opposed to de jure. But they can't agree on his continued employment. Ross says there's a conflict. Let him go work for the LC. Justice Chimes says, how can that not be a conflict? One wants him fired, one wants him hired. Read her oral argument, questions she posed to counsel below. No one had an answer for that question because it's a flat-out conflict of interest. 12 cases that we found so far have been diverted. The LC is advertising in competition with the PC. How could that effectively function a corporation? It's not, it's nonsense. It just isn't true. And we're planning to prove that at the time of the hearing. But to say now that it should be decided as a matter of law just strains the credulity of the argument. It really does. I mean, he raised the radon case. I didn't know, wasn't sure he would raise that case. And I know, I don't want to take too much of your time, but the radon case is particularly interesting to me, 1954 case. The majority opinion was written by Charles Desmond. Now, Charles Desmond wasn't the chief at the time, it was Lewis. Charles Desmond and I have a very close relationship. My son's middle name is Desmond. And he wrote that opinion, but he wrote the opinion and it was based upon profitability. He cited it in there, and it was before the statute said that's not the only metric. But the irony of that decision is that the dissenting opinion was written by Judge Fould, Stanley Fould. He and Desmond were like this. They were the quiz kids because they asked all the questions. And Desmond just loved him dearly. When he wrote the dissent, Fould said in the dissent, you need to have a hearing here. You can't decide it on this record. There's got to be a hearing, just like any other rational analysis of this dispute is. And there has to be one. I wish there didn't have to be one, but there does. And the final point I can make is on the receiver. Well, I can talk to you about Klein as well. You know, I've had the Klein case thrown at me so many times by my colleague and friend for years that I think I know David and Susan on a first-name basis. It's nothing like our case. It's a 5-sentence opinion that doesn't really lend much. I went back and read the whole record. Right? David wanted to make more money. Susan wanted to work part-time. David wanted to expand the practice. Susan wanted her father's practice of Social Security. There was very little dispute about the management of the firm. In fact, the court held we don't need a hearing because the dissension is manufactured and illusory. Well, if there's anything that is true about our case, there's nothing that's manufactured and certainly not illusory. It's detailed chapter and verse. So the Klein case really, in fact, doesn't help them very much. And finally,